Well, hello and welcome back to my channel. I hope you're having a great day. So on Monday is the start of a 3-day hearing. So if you've been watching my channel, you'll see that there is a few videos about an Australian politician who is suing the media, particularly the Australian Broadcasting Corporation, for defamation. Now, that case is on hold at the moment because his lawyer has to defend an allegation that she has a conflict of interest and that she is not able to act for him. Now, they've actually made all the files public interest. Hallelujah! So where I was getting bits and pieces before, we actually have the same thing. Now, there's a lot of redacted information, which is fine. But I thought we'd go back for a little bit and have a read of these documents. So there'll be there could be several videos on this. So I'm not going to have them go beyond 30 minutes, just so not to bore you. So this is the originating process. So this is from Miss Dyer to Sue Chrysanthou. To the respondent, the applicant applies for the relief set out. The court will hear this application. Now, this was also set as an urgent. So this jumped the process. An order pursuant to Section 23 of the Federal Court of Australia, 1976, that until further order, the respondent be restrained from acting for the applicant in proceedings in SD 206/2021 in the Federal Court of Australia. An order pursuant to Section 37AF of the Australian Federal Court on the grounds that the order is necessary to prevent prejudice to the proper administration of justice, to preserve confidentiality, legal professional privilege, that the affidavits filed on behalf of the applicant, including exhibits or annexures, are confidential, and their publication or disclosures be prohibited, and costs. So they want the relief set out in Order 2, that the proceeding be conducted in the absence of public on the basis that the presence of the public would defeat the ends of justice. Order of the documents be effected on the respondents. So there's the email. An order that the time of service of the originating application filed on the 10th of May and all affidavits in support be abridged to the 10th of May. So they're really wanting it to be sped up. So it's now classed as a public interest because what they've done now is they've added Christian Porter to the proceedings. And so now, because his matter is a public interest case, this is our public interest case, which works for us because now we can have a look at it. So this was the court order. So we know that it was sped up. So to make so for a party to make an application, so the court ordered, under the rules be dispensed with, Charles Porter be joined as a party to the proceedings. And then he outlines the dates. So the applicant files her evidence before 12 p.m. 13th of May. So the unredacted version of evidence. So the lawyers and the judge get an unredacted version. Everyone else gets a redacted version. And so these are the dates. Concise statements speak in the redacted form annexed to these orders. Liberties to parties and nationwide news applies on a 12-hour. So this is a introduction and the need for a non-publication order. So this is why. So let's have a look. The respondent, Ms. Chrysanthou, is a barrister and senior counsel. She provided professional advice to the applicant, Ms. Dyer, in late 2020 and early 2021. On November 2020, Ms. Dyer and her solicitors, a junior barrister and another person, attended Ms. Chrysanthou's chambers for a conference. Within the confines of that lawyer-client relationship, the participants in the conference candidly discussed a number of matters, which we don't know what they are because it's redacted. Ms. Chrysanthou is acting for Mr. Porter. She took the brief reporter after the conference with Ms. Dyer. She did not seek Ms. Dyer's consent to act for Mr. Porter. She assisted with the drafting of the relevant allegations made by Mr. Porter. Despite requests from Ms. Dyer's solicitors, Ms. Chrysanthou has refused to cease acting for Mr. Porter. Miss Dyer seeks by this proceedings to restrain Miss Chrysanthou from continuing to act for Mr. Porter. Miss Dyer also seeks urgent non-publication orders to prevent disclosure of information concerning the subject matter of her lawyer-client relationship with Miss Chrysanthou. So they're also trying to keep what was discussed under the lawyer-client privilege. Now, remember, if there's no lawyer-client privilege, then it can be spoken about. But if there's a lawyer-client privilege, it then calls into question the acting for the other party. So background. Miss Dyer was a close friend of a person referred in this concise statement as AB. AB committed suicide in June 2020. Prior to her death, AB alleged that she had been R by Mr. Porter in 1988. The reporting of these allegations by the ABC has given rise to a defamation action by Mr. Porter against both the ABC and Miss Milligan, a journalist employed by the ABC. On November 9, 2020, the ABC broadcast an episode of the program Four Corners entitled Inside the Canberra Bubble. In preparing the episode, Miss Milligan interviewed Miss Dyer several times informally by telephone and once formally in person, the latter being recorded on camera. These topics discussed in the interviews included AB's allegations against Mr. Porter. These allegations did not ultimately form part of the Four Corners episode. However, brief excerpts from the recorded interview with Miss Dyer were included. Miss Dyer sought legal advice from a firm of solicitors. Miss Chrysanthou and Mr. Matthew Richardson advised Miss Dyer in relation to. Miss Chrysanthou indicated that she was initially prepared to act pro bono, but if proceedings were commenced on the basis on which she and Mr. Richardson were acting, she would need to be revisited. On the 20th of November 2020, the applicant attended a conference in Miss Chrysanthou's chambers for the purposes of seeking advice in relation to redacted. Mr. Richardson, Mr. Michael Bradley, a solicitor employed by Mark Lawyers, redacted, were also in attendance. Then we've got Section 9's all redacted. During that conference, Ms. Chrysanthou came into knowledge of facts, matters and circumstances that were, and continue to be, the subject of her obligations to preserve the confidentiality of her clients or former clients' information. Ms. Chrysanthou was and continues to be under the obligation not to act in conflict with her client or former client's interests and any duties owed to her former client or former client. Ms. Chrysanthou did not inform Ms. Dyer that she was accepting a brief on behalf of Mr. Porter, nor did Ms. Chrysanthou obtain Ms. Dyer's consent to do so. Sometime after the 20th of November 2020, Ms. Chrysanthou advised Mr. Porter in connection with the commencement of Mr. Porter's proceedings, has prepared the pleading filed in the proceedings, and continues to conduct the retainer in the proceeding. Ms. Chrysanthou is under an obligation to inform Ms. Porter as her client of everything Ms. Chrysanthou knows will be assistance to Mr. Porter within the scope of her retainer. Redacted. Mr. Porter commenced proceedings against the ABC and Ms. Milligan by way of statement of claim filed on the 15th of March. And now we've got all this redacted. Okay. So now they're saying ongoing risks. So this is why they think that there's an issue. In addition to the matters identified in the proceeding section, the following information was disclosed to Ms. Chrysanthou by Ms. Dyer and others during the 20th of November conference. There's a real prospect that the matters identified in paragraph 22 will be relevant to facts in the issue. Alternatively, the credibility of witnesses called to give evidence in Mr. Porter's defamation proceeding. The disclosure of these matters to Ms. Chrysanthou, along with these identified in the proceeding section, put her in a position to form an overall opinion as to Ms. Dyer's strengths, weaknesses, honesty, knowledge and beliefs. That opinion amounts to confidential information that should not be disclosed or used against Ms. Dyer. Ms. Chrysanthou was in a lawyer-client relationship with Ms. Dyer and owes a fiduciary duty to her. Ms. Chrysanthou, by entering into a lawyer-client relationship with Mr. Porter, owes a duty to Mr. Porter to utilise any information available to her for the benefit of Mr. Porter. There is a real and obvious possibility that the information disclosed by Miss Dyer to Ms. Chrysanthou in the conference will be relevant to Ms. Chrysanthou's carriage of the defamation proceedings on behalf of Mr. Porter. In addition, there is a real and obvious possibility that the fact that the information was known to Miss Dyer and what point of time it was known to Miss Dyer and Miss Dyer's views about that information would be relevant to Ms. Chrysanthou's carriage of the defamation proceedings. By her conduct, advising and acting for Mr. Porter to date, including by preparing Porter's statement of claim, Ms. Chrysanthou has failed and continues to fail to avoid a conflict between her duty to Mr. Porter and her duty to Miss Dyer. In addition, there is a real and sensible possibility of that Ms. Chrysanthou, by continuing to act to Mr. Porter, would be required by her duty to Mr. Porter to disclose matters to him that are confidential to and subject to legal professional privilege for the benefit of Miss Dyer. So this is what they want, their summary of relief. Miss Dyer seeks the relief set out in the accompanying originating application comprising of an injunction restraining Ms. Chrysanthou from continuing to act for Mr. Porter and non-publication orders to protect Ms. Dyer's confidentiality and privilege in respect to the information disclosed to Ms. Chrysanthou. Ms. Dyer's solicitors delivered 3 affidavits and draft summons to Ms. Chrysanthou's solicitors on the 30th of April 2021. In the accompanying letter, they foreshadowed the intention to file in the Supreme Court of New South Wales, said that Ms. Dyer would seek to avoid drawing public attention to the foreshadowed proceedings so as to protect the confidential subject matter, and asked Ms. Chrysanthou not to draw attention to the foreshadowed proceedings. Ms. Chrysanthou's solicitors responded that they had said that they considered the proceedings should be commenced in court. They also said on behalf of Ms. Chrysanthou, you have requested that Ms. Chrysanthou not draw public attention to proceedings. That is unrealistic and unfair in the circumstances. In any event, Mr. Porter has been informed of the threatened proceedings and is entitled to comment on them. The reasonable inferences from those statements are that there is a real possibility that Ms. Chrysanthou or Mr. Porter will wish to draw public attention to these proceedings to restrain Ms. Chrysanthou in circumstances that Ms. Dyer seeks urgent non-publication orders pursuant to S37A of Federal Court of Australia to prevent disclosure of information concerning the subject matter of her lawyer-client relationship with Ms. Chrysanthou. There is a real possibility that Ms. Dyer's legal professional privilege and confidentiality will be compromised by Ms. Chrysanthou's continued representation of Mr. Porter. In addition, Ms. Dyer will likely be called by the ABC as a witness in Mr. Porter's defamation proceedings. She is therefore likely to be cross-examined by counsel for Mr. Porter. The applicant is at a real risk of being at a disadvantage or suffering detriment as a witness in that proceeding if Mr. Chrysanthou continues to act for Mr. Porter. So that's to say it was who prepared the pleadings, and the lawyer to say that they're qualified. So this is just all standard stuff that the court does. So then we've got notices of acting. I'm not going to look at those just to say who's going to act for them. So this is an order. So the matter is fixed for hearing on the 24th to 26th of May. The applicant to file and serve her outline submissions on 5 p.m. the 21st of May. The first and second respondents file their outlines of submission by 5 p.m. 23rd of May. The parties indicate to each other which of the witnesses are required for cross-examine, and liberty to 12 hours notice apply. And so he's been added to that. So this happened on the 14th of May. So now we've got statements now. And we've got some submissions. So let's look at the first respondent statement. So remember, there's 2 respondents now. So this will be from Miss Chrysanthou. All right. I always laugh when I see the Honourable in front of a politician's name. Sorry. I just find it funny. All right. In answer to the allegations in the concise statement dated 11th of May 2021, the first respondent says that she has only been provided with the redacted version and does not know and cannot admit any of the material that she cannot see and read because it is redacted. In answer to the allegations in paragraph 1, she admits that she's a barrister and senior counsel. She admits that she provided advice to Dyer on the 20th of November 2020 and the 27th and 28th of January 2021. Said the advice referred to in the preceding paragraph was limited to, admits that she met with Dyer, Michael Bradley, James Hook on the 20th of November, says that she attended the conference referred to in the proceedings subparagraph at a request of Matthew Richardson as a favour to him, says her recollection of that conference will be set out in affidavit filed by her, admits she's acting for the second respondent and has had that brief since the 10th of March, admits she did not seek Dyer's consent to act for Porter and says she did not need to seek such advice, says that she notified Dyer of her brief for Porter by informing Michael Bradley shortly after 9 a.m. on the 15th of March, admits she drafted the originating application, statement of claim and reply for Porter in his proceedings in consultation with and on instructions from Rebecca Giles' solicitor, and otherwise denies the allegations of paragraph 1. In allegations of paragraph 2, she says that on the 15th of March, Dyer, by her solicitor Michael Bradley, asserted that Chrysanthou had confidential information of Dyer, but did not ask at the time to return the brief for Porter. On the 24th of March, Dyer, by her solicitors, asked Chrysanthou to not do any further work for Porter, and Chrysanthou refused to give that undertaking. 23rd of April, Dyer, by her solicitors, advised if Chrysanthou did not return the brief by 4 p.m. the 26th of April, that she would approach the court without notice. On or about 4:30 p.m. on the 30th of April, Dyer, by her solicitors, advised if Chrysanthou did not return the brief by 5 p.m. the 2nd of May, she would commence proceedings in the Equity Division of the Supreme Court of New South Wales by approaching the duty judge on the 3rd of May. At about 11:30 a.m. on the 10th of May, by her solicitors, notified Chrysanthou that she would be commencing proceedings. She is of the view that by reason of the cab rank rule, she's prevented by returning the brief for Porter. She's not provided any information by Dyer that would require her to return the brief in the Porter matter. Chrysanthou does not plead to paragraph 3, which makes no allegations of facts. In allegations to paragraph 4, Chrysanthou states she does not know and cannot admit to the nature of the relationship between Dyer and AB, understands that AB committed suicide on the 24th of June 2020, admits that it is alleged that AB made claims that she was R by Porter in 1988, admits that the ABC published an article written by Louise Milligan that identified and defamed Porter by repetition of allegations said to have been made by AB, admits that Porter has sued the ABC and Louise Milligan in relation to publications of the article to the preceding subparagraph. In answer to the allegations in paragraph 5, Chrysanthou admits that on November 9, 2020, the ABC broadcast an episode of Four Corners titled Inside the Canberra Butterball, admits Dyer engaged in a filmed interview for that broadcast, does not know and cannot admit what other interviews contact Dyer engaged with Milligan, admits that the filmed interview included Dyer discussing the allegations said to have been made by AB against Porter, admits the allegations said to have been made by AB against Porter were not included in the November Four Quarters episode, admits that parts of the filmed interview of Dyer were included in the November broadcast episode. In answer to allegations of paragraph 7, she does not know and cannot admit, if any, advice Dyer sought from ARC lawyers, does not know and cannot admit what Mr. Richardson advised Dyer in relation to, save for what is set out below. This is what she admits, redacted, says that redacted, says she attended the conference, redacted, as a favour to her friend Mark Richardson, admits she did not issue an invoice for the advice given she gave, redacted, and never intended to do so, given the matter set out in the preceding subparagraph, says she never agreed to act in any proceedings. In answer to allegations in paragraph 8, Chrysanthou admits that Dyer, Michael Bradley and James Hook attended her chambers at 10 a.m. on the 20th of November 2020. Says that Matthew Richardson attended shortly after 10 a.m. Says the purpose of the conference was to advise Dyer in relation to redacted. In answer to the allegations in paragraph 10, Chrysanthou relies on the content of her affidavit that will be filed in the proceedings as to her recollection of what was said during the conference of November 2020, admits that she has an obligation to preserve any confidential information of Dyer's that was imparted to her during the conference, says that she gave an undertaking to Dyer on March 30th, 2021 and April 26, 2021 inter alia that any confidential information come to her mind she would never disclose to any person. Says that she gave an undertaking on 26th of April that she would not cross-examine Dyer or Hook should they become witnesses in the Porter proceedings. Says that Dyer is not her client and was not her client on the 10th of March. Says that Dyer is not a party to the Porter proceedings and does not have relevant legal interest in it. Denies that she's acting in conflict with Dyer's interests by acting for Porter against the ABC Milligan. In answer to allegations in paragraph 11, admits that she did not inform Dyer that she was acting the brief or act for Porter prior to accepting the brief. Admits she did not seek Dyer's consent to accept the brief for Porter and says that she did not need to seek consent. Admits she has advised and appeared for Porter in his proceedings against the ABC Milligan. Admits she prepared the proceedings in the Porter pleadings in the Porter proceedings in consultation with and on instructions of Rebecca Giles solicitor. Admits that she's still briefed in the Porter proceedings. Admits she's under an obligation to inform Porter as her client of everything she knows will be assistance to Porter within the scope of her brief, subject to matters about which Porter gives informed consent that she does not use for his benefit. In answer to the allegations in paragraph 12, Chrysanthou admits that Porter commenced proceedings against the ABC and Milligan by way of originating application and statement of claim filed in the federal court on the 15th of March 2021. In answer to allegations in paragraph 22, Chrysanthou relies on the content of her affidavit that will be filed in these proceedings as to what she recalls was said. In answer to allegations in paragraph 23, Chrysanthou says that given the challenges to Schedule 1, 2, and 3 of the defence, the identity of the witnesses in the Porter proceedings will be called in support of any defences in unknown. Says that in the little time she spent with Dyer on 20th of November 2020, she formed no view or opinion on Dyer's strength, weaknesses, honesty, knowledge, and or beliefs. Says that despite the matters set out in the preceding subparagraph on the 26th of April 2021, she offered an undertaking not to cross-examine Dyer if she becomes a witness in the Porter proceedings. Denies that she has any confidential information of Dyer relevant to the Porter proceedings. In answer to allegations of paragraph 24, Chrysanthou says that these are matters of law and she does not plead them. In answer to allegations in paragraph 25, she denies that any information disclosed by Dyer to her on the 20th of November in conference that she can recall is relevant to the Porter proceedings. Denies there is a real and obvious possibility that any such information will be used for Porter benefit in the Porter proceedings. Denies that Dyer's state of mind as to any information or otherwise is relevant to the Porter proceedings. In answer to allegations in paragraph 26, Chrysanthou denies that there's any conflict between her duty to Porter and her interaction with Dyer. Says that Dyer has no relevant interest in the Porter proceedings, given she is not and will not be a party to it. Denies she has any way failed her duties as a barrister in relation to Porter, Dyer, or otherwise. Denies that she's in possession of any relevant confidential information of Dyer's. Denies she would be required by her duty to Porter to disclose to him matters that are confidential to, subject to the legal professional privilege of Dyer. In answer to allegations in paragraphs 27 to 29, she admits that her solicitor sent a letter containing the words in paragraph 28, Says the concerns noticed sent by Dyer to Nationwide News in November 2020 has been the subject of media reporting. Agrees any information, court documents or affidavits that contain material that is privileged should be subject of a suppression order. In answer to allegations in paragraph 30, she denies there's a real possibility that Dyer's legal professional privilege will be compromised by her continued representation of Porter. Denies she has in her possession any confidential information of Dyer's that is relevant to the Porter proceedings, and thus denies there's a real possibility they'll be compromised. Does not know and cannot admit that Dyer will be called by the ABC as a witness in the Porter proceedings against the ABC Mulligan. Says that on April 26, 2021, she offered an undertaking not to cross-examine Dyer if she does become a witness in the Porter proceedings. Says that Dyer is not disadvantaged or likely to suffer detriment as a witness that the proceedings by the fact that she acts for Porter as opposed to any other competent counsel. So again, who the pleadings were prepared for. So it says was prepared for and settled. So settled just means that they've gone through and checked it and agreed to it. So now we're going to get Porter's response. So he's now been made a respondent in this matter. So he's got, this is a 7-page one. So in answer to the allegations in the concise statement dated 11th of May 2021, the second respondent, Porter, says that he and his solicitor have only been provided with the redacted version of the concise statement, and his counsel is prohibited by Order 8 of the court's orders of 12th of May from discussing the unredacted portions of the concise statement with Porter and his solicitor. Therefore, he does not know and cannot admit to the allegations made in the paragraphs that are redacted or partially redacted in any of the allegations. So remember, only the counsel, the person, so only selected persons get the full version. So in allegations of the first paragraph, he admits the first respondent is a barrister and senior counsel, says that Chrysanthou is one of the few specialist defamation senior counsels, admitted that Chrysanthou is acting for Porter and has held the brief since the 10th of March, admits Chrysanthou drafted the original application, statement of claim and reply for Porter in his proceedings against the ABC and Louise Milligan in consultation with and on instructions from Rebecca Giles, Porter's solicitor, in these proceedings. Otherwise, does not know and cannot admit to the allegations in paragraph 1 that are unredacted and does not plead to those parts of paragraph 1 that are redacted. So how this works. So you have your lawyer, and your lawyer works with the senior counsel. So Rebecca Giles is his lawyer, and his lawyer has employed a barrister to do or a senior counsel to do all the court work. So they work together. In answer to the allegations in paragraph 2, Porter admits that Dyer, by her solicitor, Michael Bradley, requested that Chrysanthou cease to act and that she declined to do so, and otherwise says that he has not seen copies of the correspondence that was exchanged. Porter does not plead to paragraph 3, which makes no allegations of fact, but says any confidentiality or suppression orders made in these proceedings should be no broader than is necessary to protect confidential information or would otherwise be necessary to prevent an abusive process of this court. In answer to the allegations in paragraph 4, Porter says that Dyer knew AB when they were teenagers, does not know and cannot otherwise admit the nature of the relationship between Dyer and AB, understands that AB committed suicide on about June 24, 2020, admits that it is alleged that AB made claims that she was raped by Porter in 1988, admits that the ABC and Milligan published an article that repeatedly endorsed the allegations said to have been made by AB and has given rise to defamation proceedings. In answer to the allegations of paragraph 5, he admits on the 9th of November 2020, the ABC broadcast an episode of Four Corners programmed inside the Canberra bubble, admits that Dyer engaged in a filmed interview for that broadcast, does not know and cannot admit what other interviews or communications took place between Dyer and Milligan, admits that the filmed interview included Dyer discussing the allegations said to have been made by AB against Porter, admits the allegations said to have been made by AB against Porter were not included in the episode of Four Corners program broadcast on the 9th of November 2020, admits that parts were filmed of the filmed interview of Dyer were included in the episode of the Four Corners broadcast on the 9th of November. Porter does not plead to paragraph 6 because it's redacted. He does not plead to the first sentence of paragraph 7 because it's redacted, in part, and does not know and therefore cannot admit the second sentence. In relation to paragraph 8, admits that Dyer attended a conference at Chrysanthou's chambers on the 20th of November 2020, together with Richardson and Bradley. Says that James Hook was in attendance, otherwise does not plead to the balance of the paragraph, which is redacted. Porter does not plead to paragraph 9 because it's redacted. Porter does not plead to paragraph 10 because it relates to 6 to 9, which are redacted, either in whole or in part, and therefore does not know the basis of the allegations made in paragraph 10. In relation to paragraph 11, Porter admits that Chrysanthou has advised and appeared for Porter in the defamation proceedings, admits that Chrysanthou prepared the pleadings in the defamation proceedings in consultation with and on instructions from Rebecca Giles' solicitor, admits that Chrysanthou is still briefed in the defamation proceedings, admits that Chrysanthou is under no obligation to inform Porter as her client of everything she knows will be assistant supporter within the scope of her brief, subject to matters about which Porter gives informed consent that Chrysanthou not inform him about or use for his benefit, and otherwise does not know and therefore does not admit the allegations in paragraph 11. Porter does not plead to paragraphs 12 to 21 because they're redacted. Does not plead to paragraph 22 because they're redacted. Porter does not plead to 23 to 26 because they're redacted. Paragraph 27 contains no allegations against Mr. Porter. Does not plead 28 because he's not seen documents referred to in that paragraph. In relation to the allegations of 29, says the proceedings should be conducted in an open court, agrees that any information in court documents, affidavits that contain material and is subject to confidentiality, legal privilege communication should be the subject of an interim suppressant order, but says such order should not prohibit Porter's counsel from inspecting such material, and that such inspection is necessary for Porter's counsel to effectively represent Porter in these proceedings. In answer to allegation in paragraph 30, Porter does not plead the first sentence of paragraph 30 because it's based upon the preceding paragraph, which is redacted or partially redacted, denies that Dyer's state of mind or beliefs as to the veracity of AB's allegation is in any way relevant to the defamation proceedings or Chrysanthou's carriage of the proceedings, does not admit that Dyer could give relevant and admissible evidence in the defamation proceedings, does not admit that the ABC intends to call her as a witness in the defamation proceedings, says that Dyer has no legal interest in the outcome of the defamation proceedings, denies that Chrysanthou would be acting adversely to Dyer if she continues to act in the defamation proceedings, denies that Dyer is a real risk of being disadvantaged or suffering detriment as a witness in the defamation proceedings if Chrysanthou continues to act for Porter, denies there's a conflict between Chrysanthou's duty to Porter and her interaction with Dyer, does not know and cannot admit to the allegations in paragraph 30. In further answer to the entire claim, Porter says Dyer, Bradley, Hook have made public statements and statements to third parties about Porter and the defamation proceedings, such that the court must determine whether any information alleged to have been imparted to Chrysanthou on November 20, 2020, or therefore is in the public domain, or otherwise not confidential because it has been disclosed to third parties. And if that is the case, imparting of that information to Chrysanthou would not provide a basis for relief sought. The court must determine whether information alleged to have been imparted to Chrysanthou on the 20th of November will therefore remain confidential in the course of the future conduct of the defamation proceedings. Excuse me. And if the court is satisfied the information will not remain confidential, then relief should be denied. Dyer has unreasonably denied bringing these proceedings, having been told by Chrysanthou no later than the 15th of March that she would not return the brief. In the event Chrysanthou is restrained for acting for Porter in the defamation proceedings, Porter will suffer significant detriment because he will be denied his counsel of choice to conduct a defamation proceeding, which proceeding seeks to vindicate his reputation in the face of an accusation made by the ABC and Milligan of the most serious kind. Chrysanthou is the counsel with the primary conduct of the defamation proceedings on his behalf and has held that role since the 10th of March. Defamation is a specialist jurisdiction and there is unlikely to be available to Porter, a barrister of equivalent standing, skill and expertise as Chrysanthou. Chrysanthou has expended hundreds of hours working on the defamation proceedings and have a depth knowledge of factual and legal issues in the defendant's defamation proceedings. The ABC and Milligan are well-resourced opponents represented by Justin Gleeson, SC, Renee Embaum, QC, and various junior counsels. And there's a real possibility the replacement of Chrysanthou with an alternate barrister will jeopardise the prospects of the trial in the defamation proceedings being completed this year. There is no material risk that would warrant the grant of the relief sought of confidential information being misused by Chrysanthou, where Chrysanthou is not obligated to inform Porter of everything that she knows, with the assistance of him within the scope of a retainer, because Porter has given his informed consent for Chrysanthou not to inform him of any confidential matters that she learned by reason of her attendance on the 20th of November 2020 conference and communications with representatives of Dyer. And therefore, Chrysanthou has offered an undertaking to Dyer not to cross-examine her or assist cross-examining counsel in preparing her cross-examination should she be called by the ABC and Milligan as a witness in defamation proceedings. So this has been provided by Rebecca Giles, so that's his lawyer, and settled by Christopher Withers, senior counsel. So that's the person that they're working with. All right. So what do you reckon? So he's just said in his documentation that he has stated that he's told her, he's told his lawyer not to, not to give her the information that was said in that meeting. So this was his orders on the 18th. So it was listed for case management on the 11:30 on the 19th of May. So that happened on Friday. So Wednesday. And then that was on the 19th of May. That was moved, I think. Yeah. So by the 5 p.m. the 20th of May, the first respondents give verified discovery, excluding any privileged communications to the applicant, of the following categories of documents: any documents, recordings, or constituting communications between the first respondent and another person in relation to whether the first respondent should accept the brief to act for the second respondent in the federal court proceedings, NSD 206/2021, having regard for her position as a vis-a-vis the applicant. Information that the first respondent received from the applicant, Mr. James Hook, Matthew Richardson, or Michael Brady during the course of her dealings with the applicant. Any documents recording or referring to communications that took place between the first respondent and the applicant, Mr. Bradley, Mr. James Hook, and Mr. Richardson. So by 5 p.m. the 20th of May, the first respondent and second respondent give verified discovery, excluding any privileged communications to the applicant, of the following categories of documents: any documents, recordings constituting communications between the first and second respondent or his solicitor in relation to any communications between the first respondent and the applicant. The informed consent. So the judge wants to see the informed consent. Subject to variation or revocation of Order 1 made by Justice Jaggett on the 10th of May to permit the operation of this day. By 5 p.m. 20th of May, the second respondent give verified discovery to the applicant of the proposed interrogatories of the second respondent in the federal court case referred to in the case management hearing on the 14th of May. in those proceedings. The submissions of the second respondent in the Federal Court of Australia proceedings filed in support of interrogatories and signed by the first respondents, and the defence filed by the National Broadcast Corporation. So the judge wants to see, the justice actually wants to see what's been submitted in the other case, because you've got one side saying, well, she may be called as a witness. You've got the other side saying, no, she won't be called as a witness. And he's saying, well, I need to see what those documents are. So unless the Justice Jaggett has an issue with that, pursuant to law, to Rule 1.34, the requirement in Rule 2013 of Federal Court Rules for a party to make an application for discovery under that rule be dispensed with. Publication disclosure other than to solicitors and the counsel for the first respondent and other than any solicitor or counsel second respondent that is not acting for the second respondent in the federal court proceedings, NSD 206 of concise response and the first respondent other than the redacted form. So unless you're actually involved in this, everyone else can have redacted copies, which is what I mean, we're everybody else. But pursuant to 37AI of the Federal Court of Australia, publication or disclosure be prohibited other than to the counsel for the applicant and any person or by whom the publication or disclosure is permitted in the Federal Court of Australia proceedings of the document referred to in 3A. By 5 p.m, the 20th of May, the applicant gives verified discovery to the first respondent and second respondent of the following categories. So we've got notes and communications made between the applicant and the first respondent, discussions that took place between the applicant, first respondent, and Mr. Bradley, Mr. Hook, and Mr. Richardson. Any documents that came into existence after the 1st of January 2020, which records or evidences the applicant disclosing or discussing in a matter which did not explicitly or implicitly require the disclosure or discussion, to be kept confidential with any person who was not present at the 20th of November 2020 conference with the first respondent. The information or part thereof of the applicant constitutes confidential information disclosed to the first respondent at the meeting. Pursuant to 37AI of the Federal Court of Australia, any discovery pursuant to Order 7 be limited to solicitors and counsel for the first respondent and any solicitor or counsel of the second respondent that is not acting for the second respondent in the federal court proceedings NSD 206 of 2021. The applicant has leave to issue the subpoena in the form annexed to these orders. So this is the annexed concise response of the first respondent. So this is her response. We read those and they were there. So that's her response there, which we actually read. We've seen those. So they've been listed separately. So I would say you are ordered to produce the subpoena or a copy of it and the documents or things specified in the schedule of documents. So now they've got subpoenas if they need it. So details of subpoena, you must comply with this subpoena by attending to produce the subpoena or copy and its documents, things specified in the schedule below. So 24th of May 2021, 10:15, Federal Court. In this subpoena, so they've got the definitions here. So the conference means the conference which took place on the morning of the 20th of November 2020, which you attended with the applicant, the first respondent, Mr. Bradley, Mr. Hook. The first respondents means Sue Chrysanthou. The documents and things you must produce. Any documents, recordings, or referring to communication between you and the first respondent arranged in the conference. Any documents recording or referring to communications that took place. Any documents recording or constituting communications between you and another person, whether the first respondent should have accepted the brief to act for the second respondent. Any ABC proceedings having regard to her position, and information the first respondent received during the course of her dealings with the applicant. Notes. You do not need to comply with this subpoena unless it is served on you on or before the date specified. Even if the subpoena has not been served personally on you, you must nevertheless comply with the requirements. If you have by the last day of service of the subpoena, if the subpoena is addressed to a corporation, the corporation must comply with the subpoena. You need not comply with the subpoena insofar as it requires you to attend to give evidence unless conduct money is sufficient to meet your reasonable expenses of attending as required by the subpoena is handed or tendered to you in the reasonable time before your attendance. Production of subpoena or copy of its documents or things delivered by post. So if it requires production of a subpoena, instead of attending to produce the subpoena and the documents, then you may comply with the subpoena by delivering or sending the subpoena and the document to the register. So there was an address on there. If you object to a document being produced in response to subpoena being inspected by a party to the proceeding or any other person, you must at the time of production notify a register in writing of your objections and the grounds for your objections. Unless the court otherwise orders, if you do not object to a document or thing produced by your response, the subpoena being inspected by any other party, the registrar may permit the parties proceeding to inspect the document or thing. If you produce more than one document or thing, you must, if requested by a registrar, produce a list of documents thing. You may, with the consent of the issuing party, produce a copy instead of the original. Any document of that subpoena requires you to produce. A copy may be a photocopy in electronic form, and so here's all the list: doc, PDF, XLS, JPEG, RTF, GIF, TIFF. You have a right to apply to the court for an order setting aside the subpoena or for relief in respect of the subpoena, for an order with respect to your claim for privilege, public interest, immunity, confidentiality in relation to any document or thing. If you are not party to the proceeding, you may apply to the court for an order that the issuing party pay an amount in addition to conduct money as any witness's expenses in respect to loss of expense, including legal costs reasonably incurred in complying with the subpoena. Failure to comply with the subpoena without lawful excuse is contempt of the court and may be dealt with accordingly. Note 12 is without prejudice to any power of the court under any court rules of the court, including any rules of court providing for an arrest of an addressee who defaults in attendance in accordance with the subpoena or otherwise to enforce compliance with the subpoena. So there we go. So that's what subpoena looks like. So we're motoring along at the moment. So we've got submissions. Let's see. So we had that one. We've now got the lawyer's affidavits. So these are the affidavits now from both parties. This one's 9 pages. We'll keep going. We'll keep plugging along. All right. So this was prepared by Christian Porter's lawyer. And as I said, every page actually has to be signed by the person preparing the affidavit and the witness. I'm the principal director of Giles Proprietary Limited and the solicitor on record for the second respondent. This affidavit is in support of Porter's interlocutory application filed the 18th of May 2021, seeking orders for discovery of the categories of documents described in the interlocutory application. Porter seeks dispensation from Rule 2013 of the Federal Court Rules, having regard to the fact that this matter has been listed for an urgent hearing on the 24th to 27th, 2021. The facts I dispose in this affidavit are true based on my knowledge. Where statements are not made with my knowledge, I dispose the subject matter of those reasonably informed on me. And belief after making reasonable inquiries on the basis of the sources of information set out in this affidavit. Where I dispose the conversation occur, I do so with the words and that have the effect of the conversation. Exhibited to this affidavit is a bundle of documents marked RG1, references to the exhibit, followed by page number of references to that exhibit and page number. I've only seen redacted copies of the concise statement and the redacted versions of the evidence relied on by the applicant. However, it is apparent to me from a review of these documents is that an issue in this case is whether what was said in the conference pleaded at paragraph 8 of the concise statement took place on 20 November 2020 was and remains confidential. I'm aware that Dyer has publicly discussed these allegations said to have been made by AB against Porter and has publicly interacted with the ABC and Milligan. I give some examples below. On 9th of November 2020, Four Corners, Dyer was interviewed by the ABC. She stated in relation to Porter, he had that assuredness that perhaps born of privilege, that an air of entitlement around him. I think was born of the privilege from which he came. A copy of the transcript of that interview is at pages 19 to 27 of the exhibit. On the 15th of November 2020, Dyer published a tweet on Twitter using the Twitter handle Instant Rewrite. Why will no one discuss the clear inconsistencies in Porter's statement and that many witnesses to his alleged behaviour in the public bar and the careful way he passed his words when denying the relationship with staff? A copy of this tweet is on page 28. On the 17th of February 2021, Dyer published the following tweet. Not sure why we expect this government to do anything substantive about a sexual assault when it ignores allegations that one of its members is guilty of the same thing. Brittany Higgins, What You Walk Past, where members of Milligan reports Samantha Maiden and the Bella Crab. A copy of these tweets is page 29 of the exhibit. On the 24th of February 2021, Dyer retweeted Milligan, Hi Adelaide readers, it's 1 year since I was at Adelaide's Writers' Week for this incredible event. A copy of this tweet is at page 30 of the exhibit. On the 1st of March 2021, Dyer gave an interview to the ABC where she said the following. It seemed completely consuming and completely debilitating to her. She was consumed with trauma, which she told me deeply and consistently was the result of an assault that had allegedly occurred early in 1988. And her life at that point was really devoted to exploring how she could get some kind of peace with that. She was under no illusions about the difficulties that she would confront if she sought to make a formal complaint against anyone of a crime such a seriousness so far in the distant past. She made a clear decision. She was able to articulate the reasons why she had taken that decision, which were to do with the fact that bearing the trauma had not worked for her. Her life had been troubled as a result of that trauma, and she saw no other way of getting past it than to ventilate it. A copy of that article is pages 31 to 35 of the exhibit. On the 1st of March 2020, Dyer gave an interview to Sydney Morning Herald where she said the following. We had a number of conversations because we were mindful of the difficulties seeking justice through the criminal justice system. She was someone who suffered from severe mental health. Amongst all that, there was a determination and clear resolve to tell her story she had reached after clear-eyed rationalisation. A copy of this is articles page 37 to 39. On the 2nd of March 2020, Dyer gave an interview to the ABC where she said the following. The account she gave was shocking. The act she described was shocking. They were outside the experience of anyone at the time we were in our final years of school. The details she recounted, the lucidity of which she recounted, and the clear impact it had on her, all these things persuaded me immediately she was telling the truth. A copy of this transcript is pages 40 to 42 of the exhibit. On the 7th of March 2020, Dyer published the following tweet. Sadly, our friends knew spurious false memory claims would be deployed against her. We discussed it right down to the media outlets likely to promote it. Crikey News was not on our list, and their role is disappointing, but the rest are playing out as predicted. A copy of this tweet is on page 43. On the 8th of March, Dyer published the following tweet. A mere denial does not end the matter. Sharona Cootes on the flawed logic of those who hide behind the rule of law reminding us there is no right to hold office. A copy of this tweet is on page 44 of the exhibit. On March 21, 2021, Dyer published the following tweet. The number of areas of his portfolio from which Christian Porter had to recuse himself demonstrates how ludicrous it is his clinging on to this role. A copy of this tweet is at page 45 of the exhibit. On March 21, Dyer published the following tweet. Yes, appalling for Porter to be paid full-time for part-time work, but the point is more fundamental. Credible allegations that he perpetrated a serious crime remains completely untested beyond the PM asking him if it was true. Unacceptable. A copy of this tweet is at page 46. On March 23, 2021, Dyer published the following tweet. Distress ostentatiously displayed by Morrison, even as he warns to media to be careful in their glass house. Good to see he's across the minutiae of complaints within News Corp, if not the detail of our allegation against his Attorney General. A copy of this tweet is page 47. On March 23, 2021, Dyer published the following tweet. In the last week, Porter has A, forum shopped a defamation case against the ABC, B, caught lying about SG's Medivac legislation advice, C, appointed Mirabella to the Fair Work Commission, and D, still got our allegations hanging over him. How good is our AG? A copy of this tweet is on page 48 of the exhibit. On or around the 26th of March, 2021, Joe Dyer told The Guardian, speaking on behalf of the victims' friends, talk is cheap and that's all we have heard. Talk is not enough. We need to see some serious action. Dyer also stated the following. We will not allow this issue to be managed away. It is not an issue for us. It is for a dear friend who suffered greatly. So from our perspective, it can't be an issue that can be managed away. We'll do everything that is in our power to ensure that this issue stays front and centre of our agenda and the political agenda. And there is no indication that the women of Australia think it can be managed away either. Obviously, moving Christian Porter out of the Attorney General role deals with a lot of the conflicts, but he has because he was chosen to launch defamation proceedings. But the fundamental question remains whether someone who has untested credible allegations of a serious crime hanging over their head is a fit and proper person to hold high office. We would argue no. A copy of this article is page 49 to 51. On March 29, Dyer published the following tweets. It's unacceptable. Porter must stand aside from all ministerial responsibilities while a properly constituted investigation into allegation occurs. If cleared, he can return to Cabinet. The failure to seek an inquiry begs the question of what is the government so afraid? It is a stark demonstration of what Morrison really believes about this pesky woman question that he keeps lambing in Parliament and Porter in Cabinet. Laming is another politician that has some question marks over his head at the moment. As feared, nothing in relation to the credible allegations made against Christian Porter by our friend Kate has been addressed by this reshuffle. Due to Kate's tragic suicide, only investigation of the allegations to date have been, Morrison, did you do it? Porter, no. Copy of these tweets, 52 to 53 of the exhibit. On the 12th of April, 2021, Dyer published the following tweets. This is a matter for New South Wales Police, says Scott Morrison, of the allegations against his Cabinet Minister, Christian Porter. Yet, thanks to Showbridge MLC, we know the opportunity to take his statement was stymied by senior police on 3 separate occasions. Despite the support of Detective Senior Constable Samantha Meredith, NSW Pole Child Abuse and Sex Crime Squad, investigation team members DCI Mitch Caddick, and Commander of the Child Abuse and Sex Crime Squad, John Kerr-Lake. Deputy Commissioner David Hudson denied a request to travel. Kate's request to have her statement taken via Skype was declined by New South Wales Police, and offered by South Australia Police to take Kate's statement on behalf of the New South Wales Police was also declined without consulting Kate. Why? And given the above, how can the PM say the matter has been resolved by the New South Wales Police? It is more vital than ever that there is an independent inquiry into the allegations against Mr. Porter and the decisions taken by the New South Wales Police in relation thereto. A copy of these tweets is at page 54 of the exhibits. On the 6th of May 2021, Dyer published the following tweets. Christian Porter's defamation action was touted by his lawyers as a substitute for the inquiry we didn't get to have when the PM refused to read the allegations against him and the senior New South Wales Police rejected the opportunity to take Kate's statement on 3 separate occasions. Despite a defamation case always being an inappropriate forum for such serious criminal allegations to be tested, in the absence of anything else, we thought, oh well, bring it on. Now his lawyers are trying to prevent swathes of the defence evidence from being presented to their vaunted inquiry at all, which rather undermines the earlier argument that this would be a rigorous test of all evidence against their client. They are trying to prevent further batches of evidence from being made public, leading one to wonder what their client has to hide. Extraordinary, but ultimately completely unsurprising tactics. A copy of this tweet, page 55. On the 13th of May, Michael Bradley released a statement on behalf of Dyer. A copy of this statement is at page 56. I have reviewed the Facebook page of AB and observed that Dyer is friends with that account and interacted with AB before her death. It has been reported in the media that AB used Facebook to communicate about her allegations made about Porter to her friends, including creating a Facebook group to share information. For example, an article entitled "Kate was bright, brilliant, and funny" should not be defined by her alleged R. It was published by the Crikey website on the 12th of March. A copy of that article. By email sent on the 17th of May and the 18th of May 2021, I sought Dyer's consent to give discovery of the categories of documents now included in the interlocutory application. Dyer has declined to do so. Save for Category 1D, Dyer solicitors contend it would impose an oppressive burden upon her to have to produce the balance of the categories of the documents, that she should not have to give discovery of documents already in public domain. Dyer also contends that she should not have to produce copies of statements that may have made to closed social media groups because communications cannot amount to public disclosure and therefore irrelevant to these proceedings. A copy of the relevant correspondence is at 73 to 82 of the exhibits. Employees of my firm have undertaken searches of all public statements made by Dyer about the allegations concerning Porter. I cannot be certain, however, that we have been able to gather all such statements because we do not know the times, locations, or forums in which statements were made. It is possible that not all public statements made by Dyer in a different fora have been reproduced on the internet. Further, Porter does not have access to closed content on social media groups which may contain discussions in which Dyer participated about the allegations concerning him. And they've not actually included the exhibits. So on this, just so that you know, they've not included them, but that is because which I find to be interesting. Oh no, here we go, the exhibits. Sorry, I take that back. Just give me a moment. There we go, I'm back. All right, let's look at these exhibits. All right, so here's the news article, Inside the Canberra Bubble. So this is, it is vitally important that all politicians, whether they're backbenchers or ministers or leaders, maintain the highest possible proper conduct and integrity, Liberal Senator. So, Inside the Canberra Bubble, reported by Louise Milligan, goes to air on November 9th. It is replayed on, and it can be seen on ABC News Channel. Response from the Attorney General. Malcolm often summoned ministers in frustration about the amount of detail leaking from Canberra. I had one such meeting in December 2017 when Malcolm put to me the rumour that I had leaked to journalist Shari Marsken about the Banking Royal Commission. And towards the end of the meeting, he queried whether there was any accuracy to what he described was another story he heard. The answer was no to both of these. Malcolm then promoted me to Attorney General about 2 weeks after. In my time as AG, I never had any complaint or any suggestion of any problem from Malcolm regarding the conduct of my duties as AG until the last week of his Prime Ministership, when we had a significant disagreement over the Peter Dutton citizenship issue. So this is the transcript that was submitted, and there's 19 pages to this. So they interviewed former Prime Minister, they interviewed Green Senator, a Liberal staffer. So this is Louise Mulligan, Labor Senator. Like when the question is, do you think that there's a view by some blokes in Canberra that what happens on tour stays on tour? And the Liberal senator says, well, that's Louise's question I would direct to the blokes. But certainly if one conducts oneself with an appropriate standard of conduct and integrity, then whatever may have happened on tour ought to be a matter for public disclosure. So there have been lots of complaints that have come out about a sexist culture in the Liberal Party. Linda Reynolds, Liberal Senator, I do not recognise my party at the moment. I do not recognise the values. I do not recognise the bullying and intimidation that goes on. Former Deputy Liberal Leader, is evident that there is an acceptance of a level of behaviour in Canberra that would not be tolerated in any other workplace. Julia Banks, I think she's resigning, or she's stood down because of a culture. Often when good women call out, they are subject to bad behaviour. The reprisals, the backlash and commentary portrays them as the bad ones. The liar, the troublemaker, the emotionally unstable or weak. Someone should be silenced. The Prime Minister, the current Prime Minister, says there are 7 women in Cabinet. This is the highest number of women in Canberra, in federal government. Louise Milligan asks, do you think the Liberal Party has a woman problem? Former Prime Minister says, well, I think women have got a problem with the Liberal Party. It's probably a better way of putting it. I think the party does not have enough women MPs and senators. I think it is seen as very blokey. That's a real thing. That is wrong. That is wrong, full stop. Politically, it's also very mistaken. So we've got more here. So there's a WhatsApp message that's been given. Senior Liberal women, including the current cabinet ministers, have despaired at the sexism of some of their male colleagues in the private WhatsApp message group obtained by Four Corners. Each of us aspire young women to aim for leadership. How do we continue to do this in the face of the puerile backstabbing from the male party leaders, whose sole aim is to count numbers and take our place? This leads to huge party discontent and the loss of loyal Liberals who feel betrayed. So it's very interesting. So there's a Liberal staffer, a Labor senator. In my view, both political parties have an issue. So when we get into, is it appropriate for a minister to have a relationship with a staffer? It's not appropriate, and we've seen instances of that happen, and different leaders of both political persuasions have taken appropriate action. As I said, it's notwithstanding the different pressures to exist in this place, we have to maintain a high level of conduct. So there was an affair. So one of the staffers did have an affair with a minister. She said it was completely consensual, but she's lived bitterly to regret it. This is the staffer, I lost a lot of self-confidence because I didn't feel I had any power at all to be able to stand up for myself. I was just exhausted, really exhausted. So that's what I'm trying to do by speaking to you, is to stand up for myself and say, this isn't okay. The behaviour wasn't okay and the culture is not okay, and something should be done about it. So at the end of the affair, this staffer left his office and went to work for another minister. She says she was later demoted in restructure, but she felt she had no choice but to leave politics. Yeah. From what I remember, so the reporter says the former Prime Minister was the bonk ban, then it's about Barnaby Joyce. Says no, Barnaby's case triggered it, and look, it may not have happened at that time had it not been for the Barnaby issue, but it went much further than that. Do you think ministers think that it was acceptable to sleep with staff? Oh, I think there was quite a widespread view in Parliament that this sort of thing was an entirely different matter. Another cabinet minister whose contact had come to the attention of the then Prime Minister and helped inspire the bonk man was the man who holds the Commonwealth Attorney General, Christian Porter. There had been some reports about Christian, this is the former Prime Minister again. I think he recognised that his contact had not been up to the right standard. Ministers, cabinet ministers in particular, have got to be very conscious of the fact that when you're out in public, you have to make sure you're not doing anything that you know could expose you to the compromise or could be represented in a way that could expose you to compromise. Newsreader, the Attorney General Christian Porter has ordered his department to look into sexual harassment allegations made in the media by an unnamed woman who worked as an assistant in the Royal Commission. The Attorney General's role as the nation's chief law officer includes implementing rules to protect women. This is Porter. No one should have to suffer sexual harassment at work or in any parts of their lives for that matter. It's very, very serious. The Commonwealth Government takes it seriously. I think being in a good suburban Australian family is a real leveller. Louise Milligan says, like many of his cabinet colleagues, Attorney General promotes himself as a family man. The daughter, married to a lovely person, is a lawyer and has been involved in male-dominated professions for a long time. So it's something that consistently on your mind. It's something I have to talk to my staff about from time to time. Of course, it's a subject matter of conversation with your colleagues. So she says, Louise Milligan says, serious questions are now being raised by Attorney General's conduct, and they go back decades. Louise Milligan, why are you here? So there's a barrister talking. I'm here because for a long time Christian has benefited from the silence around his conduct and his behaviour. And I'm here because I don't think his behaviour should be tolerated. So Louise Milligan again. Joe Dyer was in that. So they're going through his, talking about, so Christian Porter's marriage is now broken up. Alan Trudge's marriage is now broken up. So they're still talking about Christian Porter. So they're talking about the stuff that occurred around those 80s. So it says in his 30s, Christian Porter became a Crown prosecutor. He married his first wife, but left her for a junior colleague. While Christian Porter was a prosecutor, he worked part-time at the University of Western Australia as a lecturer in the law of evidence. Four Corners has spoken to some of his UWA students who described the incidents of inappropriate behaviour. They included sexualised comments about female students and a gratuitous focus on violent and sexually graphic material in legal cases he taught. Very interesting. So again, we're going back and forth, back to Prime Minister. Talking about Mr. Porter's companion was a young female staffer who was working for another cabinet minister. They were kissing and cuddling. I remember turning around Alan and just going, oh, like, I cannot believe what I'm seeing. What are we going to do? And I sort of switched right into media advisor mode and kind of scanned the room to see, well, who else is seeing what I'm seeing? Who else is in the room? Four Corners has spoken to 5 other people, including coalition staffers who were at the public bar that night, who saw Mr. Porter's behaviour with the young woman. They were shocked by it. One man who witnessed it was a public servant. He thought Minister Porter was opening himself to compromise. He picked up the phone of a journalist and he took a photo. So now that's come out. So again, more interviews with the women. Senator Hanson-Young says, one particular conversation I remember went from being a general chat to a pretty distressed young woman who was upset about what had been going on in the office she worked in and how she was being treated as a result of people finding out. So this young woman was talking about Christian Porter and she says, yes. Well, what did she say happened? The Green Senator says, She told me she'd found herself in somewhat of a relationship, and that clearly had found herself in the position that at some point she didn't want to be there. I'm not going to speculate why or how, but she was talking to me about it, and she was very clearly distressed, and she was in the situation she didn't want to be in. And I think, that's terrible. That's a terrible position for any young woman to find themselves in, to feel like you have to question your job, your abilities, your skills, who you talk to, who you can trust in your workplace. The sense that I've had from her was that she was feeling quite isolated. She was very guarded about what she said, but she started crying. And it was quite clear to me that there was a lot more going on than what she could say. So anyway, so this goes on. So this was one of the this is the Four Corners, one of the Four Corners programs that started the defamation case. So now they've got the tweets here from Joe Dyer, tweet 1. Here's another tweet. So she's retweeted Louise Mulligan. Friends of women who accused Cabinet Minister of R call for an allegation. We're still hearing this at the moment. And this is from the ABC they've taken. So there is calls for for investigation, and this has all come about because there was an R allegation by another staffer, and from so a Liberal Party staffer was R'd by another staffer. And it's a huge mess, and it's yeah. So this is the Sydney Morning Herald. Friends remember extraordinary woman claimed by Cabinet Minister. So there was an anonymous letter sent to the police. There was an anonymous letter. So this all came about because there was an anonymous letter sent to Mr. Morrison, Senator Sarah Hanson-Young, and Penny Wong that detailed the allegations. It says the Herald and the Age have seen copies of the 2019 statement made by the woman, which alleges a violent essay. So Labor MP Daniel Molino was a friend of the woman from when they were both high school debaters. I first became aware of the complainant's allegations that she had been some years earlier by a person who's now a senior member of the federal government in December 2019. She indicated to me that she was determined to proceed with a formal complaint, and I supported her in that decision. Another woman who knew the complainant as a young debater described her as very, very clever. She is an outstanding debater. So that's that one. We've got Minister under R, cloud of R allegations to identify himself. So again, we've got another transcript. This is the 7:30 report. This is another ABC program. So one of his, now he faces a problem which really does threaten the standing of the entire government. One of his ministers is alleged to have a 16-year-old girl in 1988. Yesterday, the Prime Minister was not giving any ground and seemed to have dropped his recent empathetic stance in the latest episode of what Peter Dutton described last week as he said, she said. So they report that this is an interview that they did with him. So as I said, this all came to light after. However, the South Australian State Coroner told 7:30 the cause and circumstances of her death are under investigation by South Australian Police on behalf and direction of the coroner. Malcolm Turnbull, former Prime Minister, says she described a pretty horrific R. We are here to speak for her because she can't speak for herself. It's wonderful to have young women with strength and the eloquence of Brittany Higgins, who is coming forward and saying, I have been wronged and I'm seeking justice. So we've got this one. We've got more tweets here. Again, linked to Sydney Morning Herald article. More tweets. So Scott Morrison urged to demote Christian Porter to backbench in cabinet reshuffle. This is Friday, 26th of March. He did get reshuffled. He's in science and technology now. So more tweets by Joe Dyer. These were all put into that statement too. So this is the letter statement on behalf of Joe Dyer. On the 15th of March 2021, Joe Dyer was made aware that Sue Chrysanthou SC had accepted a brief from Christian Porter to represent him in his defamation proceedings against the ABC. On that same day, 15th of March, through her solicitors, Mark Lawyers, Ms. Dyer expressed her objection to Ms. Chrysanthou acting for Mr. Porter on the basis of an alleged conflict of interest. Her solicitors have been in continuous correspondence with Ms. Chrysanthou's solicitors since that date, attempting in good faith to resolve this dispute without the need for court proceedings. These attempts have failed. Ms. Dyer commenced proceedings against Ms. Chrysanthou in the federal court on the 10th of May. Any suggestions that Ms. Dyer has not acted in a timely manner or in good faith is false. Ms. Dyer will not be making any public comment on the matter, from the lawyer. So this is an article from Crikey. Kate was bright, brilliant and funny. She should not be defined by her alleged R. This was March the 12th. This piece discusses SA and suicide. So that's an article here. This is 16 pages long here. So this is a photo of a 17-year-old in 1988, nearly a year after the alleged attack. Oh. That was her in the debating team. So it says Kate met Porter 6 times during the debating trips from 1986 to 88. Once she said in her statement submitted to police, going to his house and meeting his mother, who is correctly named as Nerida. Their one-on-one meetups in Perth have also been documented in the 1987 letter sent between the two debate team friends assigned by INQ. According to her allegations, during the early hours of January 10, 1988, she was asked by Porter in her room in the Women's College of Sydney University. In a 2019 email to friends sent by INQ, Kate recalled noticing Porter had small strawberry moles, size of freckles on his torso. I have seen them. So does my father, she wrote. He has skin like mine and Dad's. I thought, desperate to make some sort of connection. So her boyfriend she met in 1988 says he knew something happened. It's really quite postcard sent to during her 1988 international Christmas trip. So trauma starts to surface. Says she saw Porter in 1994, the year after she graduated from university, after having dinner with him and allegedly rejecting his advances. She wrote in her statement she felt shaken but relieved, as if I had broken the spell that had been cast some 7 years earlier. She worked as a school health historian, publishing a book about the school. The book launched in 2010 with the now Finance Minister Simon Birmingham. Though her friends thought she'd go on to be an influential figure, they said the role of historian suited her. She had a photographic memory. She could reel off a quote from some historical figure. She just seemed an incredible, astute figure. So this is the Crikey. So this is an article written about her. So that says that she during the trip to Melbourne, May 2020, she checked herself into a psychiatric hospital. She was released in mid-lockdown in June and returned home in June after calling New South Wales Police the day before to tell them she did not want to proceed with the complaint. Kate reportedly cut her hair into the same hairstyle she had in 1988 and took her own life. So that's crikey. Then we've got emails. And please, colleagues, please find the enclosed proposed discovery orders. We propose that discovery be provided by the close of business Thursday 20th. Would you indicate by midday tomorrow whether you'd consent to these orders being made so we can send them to chambers? So this is the order that they've attached. Please see attached further proposed discovery orders. So they want these orders made. So they're just sending back orders back and back. Please see attached letters. Re-enclosed an email sent by our client also agrees with the time frame. However, our client does not agree to discovery orders being made in respect to categories 1, 2, 3, 5, and 6 of the second respondent's proposed orders. And then they go on to say why. Further, requiring our client to produce these categories of documents would impose an impressive burden on our client given the limited time frame. For example, with respect to Order 5 of the second respondent's proposed orders, it would not be appropriate to require our client to produce statements which are already in the public domain. Further, our client does not agree to produce copies of statements she may have been made to closed social media groups. By their nature, such communications cannot amount to public disclosure and therefore irrelevant to the issues in this order. So there you go. So that's that one. Right. So we've done that one. Right. So now we've got the affidavit of the applicant. Then we get into submissions and orders. This is really interesting, isn't it? Like, it's all going to come down to what the Chrysanthou knows about Dyer, really. Right, this is 62 pages. Wow. So we've got an affidavit, then we've got annexures, and we've got annexures. All right, so they've got annexures for the second order. So this is, I am a partner at Mark Lawyers and the solicitor on record for the applicant, Mr. Joanne Dyer. I previously saw an affidavit on behalf of the applicant in these proceedings on the 11th of May. I'm authorised to make this further affidavit on behalf of the applicant in support of the applicant's interlocutory application filed on the 19th of May seeking orders for discovery by the first and second respondent of the categories set out in the application, an interim non-publication order pursuant to Section 37AI of the Federal Court Act in respect to the first respondent's response and concise statement filed the 17th of May. This matter is listed for final hearing on the 24th to 26th of May. Due to the limited time available before the court hearing, the applicant seeks dispensation from Rule 2013 of the Federal Court Rules 2011 with respect to the discovery application process. Unless otherwise indicated, I make this affidavit from my own knowledge, information and belief based on my own knowledge and experience as a solicitor, where I depose matters and belief. I believe those matters to be true. So now we're getting to discovery. On 17th of May 2021 at 9:51 p.m, I received an email from Ms. Alana Taranis on behalf of Ms. Giles, solicitor for second respondent, Mr. Porter, proposing categories of documents to be provided by the applicant by way of discovery to the respondents. A copy of the proposed orders enclosed with Ms. Tannis' email appears at pages 6 to 8 of this affidavit. I have annexed the second respondent's proposed orders to this affidavit as a version of the proposed orders that is annexed to the affidavit of Ms. Rebecca Giles, sworn on the 18th of May, at pages 74 to 75. It doesn't include the footer, which was originally included in the proposed orders. On the 18th of May 2021, 10:02 a.m, I received a further email from Ms. Tannis attaching further proposed discovery orders. A copy of the further proposed orders attached to Ms. Tannis' email appears at pages 9 to 11 of this affidavit. I've annexed the proposed discovery orders to this affidavit as a version of the proposed orders that is annexed to the affidavit of Ms. Rebecca Giles. sworn on the 18th of May 2021 at pages 78 to 79 of RG1, does not include the footer, which was originally included in the proposed orders. On 18th of May 2021, at 12:10 p.m, Ms. Lauren Gasparani, working under my instructions, emailed a letter to solicitors of the first respondent and the second respondent outlining the applicant's position with respect to the proposed discovery orders. A copy of this letter appears at pages 81 to 82. On the 18th of May 2021 at 1:20 p.m, Ms. Gasparani emailed a second letter to solicitors for the first respondent and second respondent, enclosing the applicant's proposed orders for discovery. A copy of this letter and applicant's proposed orders are found on pages 12 to 15. On 18th of May 2021, at 2:50 p.m, Ms. Gasparani emailed a letter to Mr. Patrick George, solicitor for first respondent, requesting redactions to the first respondent's concise reply. At 17:17 p.m, Patrick George responded with the request for redactions. A copy of the redacted version of this letter outlining the applicant's requested redactions and Mr. George's subsequent response appears at 16 to 20 of this affidavit. An unredacted of this version has not been annexed to this affidavit but can be provided to the court. The time, on the 13th of May, the Australian published an article concerning these proceedings. A copy of the article is attached. So, matters relevant to discovery sought by the first respondent. At paragraph 2E of the first respondent's concise response, the first respondent states that she attended the conference on the 20th of November 2020 as a favour to Mr. Richardson. At paragraph 2, the first respondent's concise reply, the first respondent states that she informed Mr. Bradley, the managing party of Mark Lawyers, on the 15th of March, that she had accepted brief to act for the second respondent in proceedings NSD 206/2021 in the Federal Court of Australia. I informed by Mr. Bradley and very believed that the first respondent advised Mr. Bradley that she had made inquiries of Mr. Brett Walker, SC, and two other senior counsels as to whether she should accept the Porter brief. The conversation between the first respondent and Mr. Bradley is outlined in paragraph 26 of the affidavit of David Michael Bradley, firm the 10th of May 2021 in these proceedings. The conversation as disposed to by Mr. Bradley forms the basis of my belief as to Ms. Chrysanthou's inquiries. At paragraph 2G, the first respondent's concise response, the first respondent confirms she has held the Porter brief since the 10th of March 2021. The first respondent corresponded with Mark Lawyers and the applicant in respect to advice provided to the applicant during the period of the 20th of November and the 4th of March. The relevant correspondence is privileged and has been annexed to the affidavit of Michael David Bradley, affirmed the 10th of May in these proceedings and March confidential affidavit. At paragraph 23, the second respondent's concise reply, the second respondent states Porter has given his informed consent that Chrysanthou not inform him of any confidential matters that she's learned by reason of her attendance at the 20 November 2020 conference and communications with representatives of Dyer thereafter. On May 14, 2021, Federal Court of Australia proceedings NSC 206 of 2021 were listed before Her Honours Justice Jagger to attend a procedural matter. My firm obtained a copy of the transcript of the ABC case management hearing by email from AusScript at 7:51 a.m. on the 19th of May. A copy of this email together with the transcript is attached. So that's the signature of witness. So here we go. So this is the orders that they were wanting. We're going to find out what he granted soon. So these are the proposed orders. Letter between the two lawyers. Again, proposed, I think they're proposed orders. We haven't got proposed orders yet. Our unsealed copy of your client's concise response. The following paragraphs contain privileged or confidential information. So that seeks a non-publication order. This is Kennedy's. Refer to your letter dated 8th of May in relation to your question for reductions to our client's concise response. Our client makes no claim for privilege or confidentiality in respect of her paragraphs for her concise reply cited by you, which you assign belong to her, nor do we consider these paragraphs disclose the content of any confidential information or privileged communication. Our proposal in relation to confidential information in our client's proposed affidavit did not relate to the concise response. As you know from the email of Nathan Buck sent at 5:45 yesterday, the unsealed concise response was already lodged with the court registry at the time and served on all parties in the proceeding, including Mr. Porter's solicitors in proceedings NSD 206-2021. As foreshadowed in that email, we now enclose, by way of service, a sealed version of our client's concise response. Our client will not consent nor oppose any application by your client to have redactions made to the sealed version of the concise response, nor will our client consent or oppose any application by your client for a non-publication order. When our client undertake not to make the unredacted copy of the concise response public pending a ruling on the foreshadowed non-publication order. It says, Christian Porter's defamation barrister Sue Chrysanthou faces legal action. So this is now come out. Okay, and here's the transcript of proceedings from that hearing. So and so this is, as I said, this is the one that I saw, because this is the one where Her Honour just was very concerned about proceeding when the matter with Miss Chrysanthou had not been resolved. So, and then she said that she had to get Mr. Walker to attend, so she had to call. So it was adjourned, and then Mr. Walker. So this is that transcript, and it was the official transcript. So this is how the transcripts look, if you're interested. They're bold, they're in caps, the names are in caps. And down the bottom, it actually says who actually obtained the transcript. So, yeah, this goes on. There's how many pages of it is there? There's a lot. It went on for a while in the end because Mr. Gleeson, so that's all they've done. So it was adjourned to 11:42 a.m. the 26th of May. So that is the ABCs. Now, you'll notice that there is actually some there are some things missing, some affidavits, and obviously they can't have them all. So this is the submissions, second respondents. So this is the submissions. So what we might do is I might come back and we might look at the submissions, because we've done that, the concise statement. So that's from the second respondent. We've got the applicants, and we had an order on the 19th of May. So this, let's look at this order. So, which was seen. So this is the order that the judge made. And it's very similar to what was mentioned before. So they've had to have all their stuff in by the 20th. And we saw the subpoena. Yeah. So that's the concise response. Yeah. And we've seen the subpoena. So who's this subpoena of? Yeah. All right. So that's that, which was seen. So we've got submissions and we've got the concise statement, the redacted version. So let's just see if we've seen this one. Yes, we did this one. So we've seen that one. So we've really just got the submissions to look at. But they put that down here. Oh, no, that's the applicant's one. All right. All right. So we're going to come back and we're going to do the concise statement and the submissions. Thank you for watching this. I hope you're enjoying this. This is, as I said, this is just a big bundle of interest. The judge has to now work out whether there is this conflict of interest. So, as I said, he's wanting to know documents related to the other case because he needs to know what's at stake here, you know? Very weird. So also remember, I'm not a lawyer, so I'm only giving my opinion based on what I read. But, you know, I do like that it is fairly easily, it's an easy read. I do like that. So as I said, Monday, they start this hearing and they start battling it out. And I will do my best to watch it all and give you a summary for it. So I'll do my best. All right, I'll catch you soon with part 2.